Good morning. Shall we start the class? Is it audible now? Can someone send the message or through the chat box? Okay. Then we will start from the last class. Actually, before starting the today's discussion, we will go through some recap from the previous classes. And particularly the last class we have seen what is financial institution and their key functions and importance of the financial institutions and the why the financial institutions is managed and how it different from other institutions. So we have mentioned that financial institutions are managing with the depositors fund than the owners fund. So we have to give or the regulators are appointed and regulators monitor the financial institution very stringent manner than the compared to the other institutions. And then we have seen about the incorporation of the companies, and then we move to the different type of companies and the company name requirement. Under that we have seen the private companies limited by the guarantees, and offshore companies, overseas companies and all, and what are the difference between these companies. And then we move into the article of association and what are the general contents of the article of association. Those things we have discussed the last class. And then the shareholders of the company, their rights and obligations we have seen, and the different type of resolution also we have discussed in the last class. Do you all have any questions or anything do you all wanted to ask from me regarding the last class? Of course, you don't. If you don't have the any doubt, what I can do is normally, generally in the classes, what I am doing is, if the students doesn't have the class, the any doubt or any queries, generally I am asking the question from the students. If it is a physical class, generally I am asking this question from the students to get the feedback whether they have understand properly or not. So if you have any questions, you can ask from me, or otherwise I'll just ask one question to check whether you have understand the topics which we have discussed in the last class. In which way it's convenient to you all. Whether I am asking the questions or you all wanted to ask from me. Okay, I'm asking a question from you. One question. When I am when we are discussing when we were discussing the private companies, I have mentioned you all that the private companies has to maintain a interest register, but by passing a special resolution, they need not to, or they give up to maintain the interest register in the company. But if any of the shareholder asks from the company to maintain the interest register, then the private company has the obligation to maintain its interest register, which we have discussed in the last class under the private companies. Now I am asking a question from you all. What is interest register? Because I have several times I have discussed about the interest register. I have mentioned that it has to maintain, interest registers has to maintain, and it can be give up, and then if the shareholder wants, they have to maintain the interest register and all. Okay, since you all don't have the questions, I am asking from you all to understand what you have understand about the our discussion. So what is the meaning of interest register? Can somebody pass the answer through the chat box? What is interest register? If you all have studied in a proper way, definitely you all must ask this question, or there should be a question raised within you all that what is interest register? This man is telling about the interest register. What is that meaning? Can someone tell? Okay, I myself giving the answer. The interest register is a register to record any transaction or proposed transaction with the company in which a director has the interest. So which we will study that matter in today's class as well. Some transaction directors has the interest, personal interest. Those type of transaction has to be registered in the interest register. So that is the whole purpose of maintaining interest register. It means a register to record any transaction or proposed transaction with the company in which a director has the interest. So those type of records will be maintained in the interest register. I think you have understand these things. Okay, which we have discussed in the under the private companies in the last class. So that is the answer of the interest register. So students, please study then and there, then that will be easy for you all to prepare ready for the exam. If you all have any doubt in the previous class or any class, you can ask the question before starting the class, or even between the class. There's no any limitation. You can ask the question from me. I'm happy to answer for a doubt. Okay. Having that, we will move to the next section or today's discussion. Actually, today's class I have structured into two ways. Which one? The first section is about the continuation of the last class. Actually, in the last class, we have studied those things. I have what is the finance institution and shareholders' rights and a special resolution, ordinary resolution, and how to use the powers and everything. And as a continuation of that, I'm going to discuss today also some of the other section. It means it's related to mainly related to the directors of the company. So that will be the first part of this today's class. And in the second section, I'm going to discuss about the I'm going to discuss about the licensing procedure of the financial institutions. Because if it is the bank or any finance company or leasing company or any insurance company or any financial institution, anybody can't just start up the institution. If I wanted to start the bank, I can't start the bank, and I can't raise the deposit from the customers because there is a licensing procedure. So for a bank, there's a licensing procedure, different licensing procedure for finance companies and insurance companies, stockbrokering companies. There are different type of licensing procedures, and there are different type of regulators regulating these institutions. So today, in the second section, I'm going to discuss, okay, these finance institutions, who are the regulators and what are the licensing procedure. That will be the second section. The first section, of course, the continuation of the last class, which we have discussed about the preliminary things of the Company Act. Okay, as a continuation of that, today I am going to discuss first part. I am going to discuss about the directors of a company. What are the prime duty of a director? It is nothing rocket science here. In the primary duty, in these things are listed out in the Companies Act number 7 of 2007. Companies Act describe these duties. Accordingly, the primary duty of a director, the first duty, act in good faith what he or she believe to be in the interest of the company. Okay, first he has to believe that I am doing, or he has to do the things in the interest of the particular company. If he acts on the interest of some other companies, that is not a duty. Actually, his primary duty is act good faith with what he believes that to be in the interest of the particular company. That is the first one. The second one, however, in case of a director of the company, which is a wholly owned company of another company, may, if expressly permitted in the article, act in the manner that he or she believe in the interest of that company, even though it may not be the interest of the company that he or she is the director, but it is. The first we say that if a director, he has to act in the interest of the particular company. For example, we take that the X company X. Okay, the director, he is the director of the company X. So what he has to do is he has to act in the interest of the company, particular company X. That is the first prime duty of the director. But there's an exemption. For example, A company is the holding company of the X. Okay, the A company is the 100% owner of the X company. In that circumstances, where A company has the 100% ownership in the X company, okay, in that circumstances, as well as if it is mentioned in the article of association, then what the director can do is he can act on the interest of the A company, even though he is the director of the company X. That means it simply says that if it is a holding company which has a 100% ownership, and if the article of association also permit that, then even though company X director, he can act on the interest of the company A. It means interest of the holding company. Understand? Okay, so that is the first prime duty, the act in the interest of the company, but there's an exemption. What is the exemption? If it is a 100% on holding company, then an article of association also permits, then the particular director may act on the interest of the holding company. That is the exemption phase. The third one is a director shall not act or agree to the company acting in a manner that contravenes with the provision of the act or article of association. Any director should not act which are contravened with the provision of the Companies Act or any act or article of association. It means something illegal things or something not acceptable by the any act or article of association. Then the director shall not or not agree to act in that manner. Okay. Then fourth one is not act in a manner which reckless or grossly negligence. If it is a negligence, he can't act in as a negligence manner. And the fifth one, exercise degree of skill or care that may be reasonably be expected of a person of his knowledge or experience. What is this meaning? What is the meaning of this? For example, if a person he has a knowledge, say he is a chartered accountant, he is appointed as a director of a bank or finance company. So when he is doing the exercising his power or using his skill, he has to use that the expected of the person of the knowledge and experience in the reasonable manner. He has to deliver his duty, or he has to act as a person expected, or the knowledge and skill expected from the chartered accountant. So in the accounting matters, he has to give full cooperation, or he has to act as a chartered accountant. So he has to use his knowledge and experiences in the expected level. So these are the prime duty of a director. It is the prime duty of the director of a company. Okay. Then any questions or any doubt from you all? Come on, students, you will have to Of course, you will have to ask any, if you have any questions, you will have to ask. That is better for you all, and it is better for other students also. They can clear the their doubt as well. Okay, if you all don't have the any questions, I can move. Before moving to that, I'm asking a question to clarify the second point further. For example, the company X is a fully owned company of the company A. The company A is a holding company, and company X is the subsidiary company, which is the example I have given to you. Okay, now we are twisting the example. Okay, company A is the holding company of the company X, but the ownership is not 100%, the 75%. Okay, in that scenario, whether a director can act on the interest of the company A. Did you understand the question? The company A is the holding company of the X. Okay, earlier we have seen that company A has the 100% ownership. But now, instead of the 100% ownership, now we are seeing that company A has the only 75% of the ownership. In that circumstances, a director of the company X can act on the interest of the company A. It is allowable or not? Can anybody answer the questions? Did you all get the questions rightly? No. Yeah, that is the answer. Because it is not the fully owned company. If it is the fully, there are two conditions for this. To get that exemption, there are two conditions, primary conditions. First, it should be a fully owned company. The second, it should be permitted in the article of association. In that circumstances only, the company director of the company X can act in the interest of the company A. Other than other circumstances, they can't act. So the answer no is absolutely correct. Okay. Then I'll move to the use of the information and advice. If a director act in the good faith, make proper inquiry, and has no knowledge that reliance on the certain information is unwarranted, he or she can rely on the information and advices of the others. It is reasonable. That means a director, he may not have the every knowledge. Okay, in that case, if he has the lack of the knowledge, or he has some information, he wants some further information, in that circumstances, that particular director or he or she can rely on the information and advice submitted by or get it from the other people. A director may rely on the reports, statement, and financial data and other information prepared and supplied on professional or expert advice given by the following persons. So it also defined in the act from whom they can get those type of information. First, an employee of the company. Okay, if the employee of the company giving the expert information to the director can use that information for decision making purpose. Okay, an employee. A professional advisor or expert that the director believed to be competent. Okay, and any other director or committee of directors in which the director did not serve, to which the committee is authorized. For example, in terms of risk management. Okay, in a bank's risk management, there is a subcommittee, risk management subcommittee. Okay, in that case, that subcommittee giving some information, so the director can use that information and come into the decision making or act in a good way. Okay, so in the slides we are trying to emphasize 2 points. The first one is a director if director does not have adequate knowledge in the particular area or particular decision making process, then he or she can rely on the information and advice of the others. The Company Act permit for that. And that circumstances, the Company Act says that there are three group of people he or she can get the information. First is employee of the company. Second is professional advisor or expert of the director experts. And third one is any committee, the competent committee appointed to deal the matter in the company. So these are the three matters it has been mentioned. These are the two things it has been mentioned about the use of information and advice by a director. And the third one, which is the somewhat important things, which you will have to keep in, because the some questions are coming not directly but indirectly. The director's interested transactions, or the transaction in which the director is interested, which is 191, section 191 and 92 deal with the Companies Act. It says that a director of a company is interested in a transaction to which the company is a party and the director is a party or will or may derive a material financial benefit from the transaction. I'm simply saying this before going to the theoretical part. I'm simply saying that, for example, there's a company R. Okay, that's a company R. In that company R, there may be directors A, B, C. There are three directors A, B, C. Okay, the company R may enter some other transaction or transaction with several parties, other parties. Okay, then in that scenario, sometimes those one of the director may have the direct connection with those transactions. For example, the director A or director B, for example, let's assume director B. The director B is a director of or director B has some own company, IT company. Okay, we are assuming that the company R, where three directors are there, the director A, director B, director C. The director B has a IT company. In that IT company, they are providing services. Okay. Now, company R enter into an agreement with the particular other IT company to provide some software to this company. In that circumstances, this particular director has some financial benefit through that particular transactions, because he has a company, own company, and the own company enter into the agreement or transaction agreement with a particular company to provide the service software to this company R. So in that case, in that particular transaction, the director B has the interest. So this is the director interested transaction, because one of the director has some interest in the transaction. So this type of transaction has to be entered into the interest register. So before enter into the interest register, there are some definitions. How can we identify the interested transaction? Because we can't just say that everything is interested transaction of a director. There should be some definition. So the section 91 and 92 of the Company Act giving the definition. Okay, what type of the transaction can be considered as a director interested transaction, or transaction in which director has interested. It says that a director is one side is a director of the company is interested in a transaction to which the company is a party and the director is a party or will or may derive a material financial benefit from the transaction. So we can see the early example. In that example, the company, the director B may get the material financial benefit from that providing software transaction. So in that case, it's a director interested transaction. That is one condition. The second condition is the director has a material financial interest in another party to the transaction. Okay, where other party enter into the transaction, but this director has the material interest on that particular other party. That may be other example. We can say if other company provide that, this director also director in that particular company, or he has the material ownership in that particular company. Then in that case, again, it is a material financial interest in another party. I think these are the things we will discuss under the corporate governance issue as well. But this is the Company Act provide some information, some conditions. Okay, what are the in director interested transaction? And third condition is a director or officer or trustee of other party to or person who will or may derive material financial benefit from the transaction. Ultimately, whether we have to see if any transaction company entered through the transaction, if any of the directors are getting material financial benefit, then that transaction, that sort of transaction will be considered as a director interested transaction. The fourth one is a parent or child or spouse of other party to a person who will be may derive a material financial benefit from the transaction. And finally it says that is otherwise directly or indirectly materially interested in the transaction. So ultimately most of these, everything is concerned, the idea or principle behind these conditions are whether to identify whether the particular director has a material transaction or not. That is the ultimate idea we have to identify the director interested transaction. Any doubt you all wanted to ask from me? Then the such transaction should be entered in the interest register. That's what I have already explained you at the beginning of the class. I have asked you what is interest register. The interest register to record any transaction or proposed transaction with a company in which director has the interest or director is interested. So that is the interest register. So here it says that all the such director interested transaction should be entered in the interest register. Now you all can, I think it's easy to you all to connect or understand this concept. And should be disclosed to the board. What does it mean? If any director, he believes that this particular transaction are interested transaction and there are more than one directors in that company, then the particular director should disclose that to the board saying that, okay, in this particular transaction I have interested the material financial benefits. So it is a director interested transaction. So he has to make the declaration or disclose to the board. Then another thing is disclose in the annual report also required. If there is any director interested transaction, that should be disclosed in the annual report. And failure to disclose will not affect the validity of the transaction, but director who failed to comply with the requirement in the act shall be guilty of offense and liable for punishment. So these are the first, and then the last slide we have seen what is the director interested transaction, and this slide we are seeing that what are the other things has to be done related to the direct interested transaction, where it says that it should be registered in the interest register. Second, it says that the particular director, director should disclose to the board, okay, this transaction as the direct interested transaction, and that should be disclosed in the annual report as well. Then fourth one, failure to disclose will not affect the validity of the transaction, but the particular director should be punished, and he has to find he shall be guilty of offense. So these are the relevant things related to the director interested transaction. Of course, there are questions. What are the director interested transaction definitions? So somebody has to answer. How to when there's a question or short notes, director interested transaction, then you will have to give in this answer. So first you will have to say what is director interested transaction, and then what are the circumstances you have to give for 5 marks. Understand? Anything, any doubt you all wanted to ask? Yeah, there's a question under the use of advice and transaction. Professional advice or expert believed to be competent. Is he outside of the company or not? Yes. That is, there's a question that when the I think it's related to the this professional here in the second point. It says that the director may use the others' opinion or advice, information to take to act in a good faith. In that circumstances, I have mentioned that a professional advisor or expert that director believes to be competent. There's a question from a student. He asked that whether he can he be the outsider or not. Actually, it doesn't matter whether it's an outsider or not, because sometimes they have to, or director, even India director board or particular director may believe on the outside expert opinion. So in that case, they have to get the opinion from the outsiders. For example, sometimes we can obvious example the auditor's accounts, audited accounts. So they are getting the advice or information provided by the outsider of the company, the auditors, external auditors, and based on that the report, audit report, and management letters and all sort of the information, they act or in a good faith of the company. So the answer is okay, when they are getting the professional advisor or expert, then that experts may be outsider of the company. That's not an issue. But if it is an employee, obviously it's an inside. And the third point also, the committee of the directors may be inside, but there may be some outsiders in the committee. But it's a committee as a whole when they are providing. But the second point, it can be the insider or can be the outsider. Insider, for example, chief risk officer. Chief risk officer may provide some information to the director. Then based on that information, he can act on in the good faith of the company. But sometimes it may be the outsider. For example, if it is the auditor, then outsider, completely outsider. But based on their letter, the management letter or their advice, their expert knowledge, the directors may act in the good faith of the company. Okay, I think you would understand now what the point. Okay, then if that is okay, then I'll come to the director's interest. That's all about the director's interest. This is also something important in a company directors. The use of company information. A director who has information as a director or an employee of the company which would not be otherwise be available shall not disclose that information to any person or make use of or act on except. So it's generally it's a general rule for any bank or any financial institution. It may be a general rule. It is applicable to the director as well. If a director X, he as a director, he gets some information of the company. As a director, employee, why it says that if it is an employee or director? For example, executive directors may be employee of the companies. So as a director of the, who get the information as a director and employee of the company, that's not a matter. But which is available, he as he is a director only, that information is available. Otherwise, it is not an available information, or the simply says that it is not publicly available information. Since he is a director, he gets that information. In that circumstances, he or she shall not disclose that information to any other person or make use of or act on that information. But there are exceptions. But before that, we will see that what is the rule. I can give an example for this. The example is, for example, as a director, he get to know that, okay, company going to declare the dividend. Or company going to declare a bonus to the shareholders. So as a director, he get that information. Otherwise, it is not publicly available because it has not been taken as a decision. But that idea is going among the directors. So he gets some information. Okay, the company has excess profit, so they are going to declare the bonus to the shareholders, or to boost the company share price. They are going to declare the bonus, issue the bonus issue the shares. So that information, as a director, he get that information. In that circumstances, he should not disclose that information to any other person. For example, his friend or his wife, his son, or he should not disclose that information. And make use of that information, because now he's okay. They are going to disclose. They are going to issue the bonus shares. Then in that case, in the share market, the share prices may increase. Then by make use of that information, he or she should not buy shares in the stock market. We make use of that information, act on. So these are prohibited by the using of company information by the director. But there are some exceptions. What are the exceptions? For the purpose of company, he can use that information. Okay, he get as a director, he get some information, but that information he is using for the purpose of the benefit of the company. Then that is allowable. And as required by the law, okay, if it is a required by the law, then he has to disclose to the court. Even the court issue order that to disclose any confidential information, and that circumstances that the particular director cannot say no. He has to disclose it. So required by the law, where the article of association authorizes. Okay, even though it's an information he get as a director, but article of association permit that, okay, in these circumstances you can disclose those type of information. Then that in that circumstances, the particular director can disclose that information, where the board authorizes the director and such authorization is entered in the interest register, then they can disclose that particular information. Understand? So there is a restriction to use the confidential information of the company, particularly the confidential information, non-publicly available information. So he get that information as only as a director he got that information. So he or she, that particular director, shall not disclose that information to any other person and make use of it. That is the simple understanding of this slide. Any doubt you wanted to ask from me? Okay. Then we will move to the other section that is also somewhat you'll have to keep in mind. Appointment and removal of directors. It is some general conditions to appointment and removal of the directors. Basically, the removal of the directors are more emphasized in this slide. The first, if it is a public company, there should be at least 2 directors. Otherwise, at least 1 director is enough. If it is a private company, 1 director is enough. But if it is a public company, it should be at least 2 directors. But there are some clause for the disqualifications. If it is under 18 years of the age, so he cannot become the director of the company. Undischarged insolvency. If it is an insolvent person, then he can't be. Who is the prohibited from being a director? Some people are blacklisted to being a director. Maybe involved with some forgery or fraudulent activities. So those type of prohibited people being a director, prohibited from being a director, then they can't be the director. Adjoined to be the unsound mind. Of course, everybody know that unsound mind. In that case, he can't be the director. Because if it is unsound mind, he can easily the agreement entered by him will not be the valid. Maybe not a natural person. For example, the last class I told you, company is an artificial person. So a company cannot be a director of other company. It should be a natural person. If it is not a natural person, he or she can't be the director. He or she, I can't say this he or she, it can't be the director. If the other company cannot become the director of this company and does not qualify as per the article of the particular company. Sometimes article of association may restrict, okay, this type of people only can be the director. So in that case, the particular director cannot become the director. For example, I'm just giving the example. It may not be the true, but just giving the example. They say that, okay, director should be the Western province person. Then a person from the Southern province or Central province cannot become the director. He should be the permanent resident should be in the Western province. There may be the control, some clause in the article of association. So in the particularly the company says some clause, then he can't be the director of the company. So these are the things we have to keep in mind about the directors. So if it is a public company, there should be 2 directors. If it otherwise 1 director is okay. And there are some disqualification to become the director. The first one is under the 18 years age, undischarged of insolvent, and prohibited from being a director, adjoined to be unsound mind, not a natural person, does not qualify as per the article of the particular company. These are the things. Okay. Other requirement. There are some other requirement which give some condition about the directors. Director should be give his consent to be appointed in the prescribed form and certify that he is not disqualified from being appointed or holding office. This is directly mentioned, I think. The director should give his consent, his or her consent, to be appointed in the prescribed form. And he has to give that, he will certify that, okay, I am not disqualified from being the appointed or holding the office. That is the first thing. And the second thing is, retiring age in the public company or a private company that is a subsidiary of the public company, 70 years. Okay. So maximum retirement age of a public company or private company, which is the subsidiary of the public company, then the 70 years. So simply we can say public company or its subsidiaries, the director should be 70 years. However, can be reappointed upon the passing of resolution at the general meeting for a 1-year period. This is an exemption. There are in the legal OA Act, there may be most of the cases there may be some exemption. So this is one of the exemptions. So the generally if it is a public company, it should be 70 years. But if it is the they can reappoint that passing resolution at the general meeting for 1 year. The director has a duty to disclose his age when he attains 70. Okay, when he is reaching the 70, he has to disclose, okay, I'm reaching the 70. And any lower age specified in the article. Particularly, some companies, there may be low age. Okay, article of association cannot have the maximum age. Okay, if it is a generally 70, they can't keep it as 80. Okay, in our company, there may be a director in the 80, but they can restrict. Okay, in our company, the director's maximum age should be 65 or anything. If that is his low age is specified in the article, then when a director attaining to that particular age or 70, he has to disclose, I am reaching to 70, I am going to retire. Okay. Then board proceedings are governed by the article of association. So in the directors and the board activities, generally directors are the activities in the board. So board proceedings are governed by the article of association. Remuneration and other benefits decided by the board as article permit or by other ordinary or by an ordinary resolution. So these are the some of the requirements about the directors, and other one is granting loan to a director should be in accordance with the provision of the act. Okay, so when there are loans granted to particular director, for example, if it is a director of the bank, so when it is the granting loan, it should be the provision of the act. And if expressly authorized in the article of a company, can indemnify a director for any cost incurred by him in any proceeding. That related to liability for any act or omission is capacity as a director, and in which judgment is given in his favor, or in which he or she is acquitted or discontinued granted relief. So in that circumstances, an article of association permits, and then they can if express then they can indemnify a director for any cost incurred by him in any proceeding. So these are the, I think these are the things are related to the director and the director related matters. If you have any questions, I can answer. The other one, the last one is a director who believes that company is unable to. Okay, this is something else. Before that, we will clear these things. Okay, you will have clear with this. I think this is very straightforward conditions. And if you all have any questions, you all can answer. Otherwise, I will move to the other area. Okay. Okay. This is also related to the director, but this is very specific requirement of the director, or the is related to a director. A director who believes that the company is unable to pay its debt as they fall due, sign of insolvency, should call a board meeting to consider whether the company should apply to court for a winding up and appoint of a liquidator or administrator. So what is the meaning of insolvency? What is the meaning of insolvency? Okay, we will see that. I think next slides will explain you the insolvency or solvency. We will look into that. Before that, so if a director believe that the company is unable to obey his debt when it's fall to due, and he believed that it would be the case, then he should call the board of meeting and consider whether we need to appoint for a binding, we have to binding appoint for a liquidator. This is very important role of a director. If at any time it appears the net assets of the company are less than half of its stated capital, the board should within 20 working days call an extraordinary general meeting with due advice and information. Okay? This is another condition. If a company's net assets of the company is less than the half of its stated capital, serious loss of capital, the company should within 20 working days hold an extra general meeting with due advice and information. Okay, so these two are related to the insolvency. So we have to see what is insolvency before going to the stated capital. Okay, we will see the stated capital and go the insolvency, because here they say that if it is the less than half of the stated capital. So in that case, we have to see what is stated capital. The stated capital means total of all amount received by the company or due and payable to the company in respect of the issue of the shares and in respect of all on shares. So stated company, those who have studied the accounting and all can easily understand this is all amount received by the company or due and payable to the company in respect of issue of the shares, the shareholders' stated capital. Where company are issued for a consideration other than cash, the board of directors will decide the cash value. And stated capital can be reduced by special resolution. That is other condition related to the stated capital. The stated capital can be reduced by the special resolution. And public notice should be given before 60 days of passing such resolution. So these are related to the stated capital. And we will move to the solvency test. Solvency test, of course, saying that the board is required to satisfy the solvency test and obtain the certificate of the solvency from the auditors before any dividend distribution. Okay, that is something else. Before the company, any company based on the Companies Act, before making the dividend, they have to get the solvency test from the auditors. So and okay, that's a word always using, but it's solvency. Solvency, a company is able to pay its debt as they become due in the normal course of business. We can simply say in a different way, if a company's assets, the present value of the company's assets are higher than the present value of the company's liability, in that case, the company is solvent. For example, simply we can say, okay, my total assets, the company's total assets is, present value of the total assets is 1,000 million. And the present value of the total liabilities is 800 million. In that case, it is passing the solvency. It's a solvent. The company is solvent. But in a case, the present value of the company assets is 1,000 million, and the liability is 1,500 million. In that case, the company become insolvent. They don't have the enough assets to pay their liabilities. There's a question in this section, solvency. This is several times, because they are just always asking to compare the solvency and liquidity. We will study these things in the risk management section. You just now you keep it in the mind. What is solvency? Solvency, a company is able to pay its debt as they become due in normal course of business, and the value of the company asset is greater than the value of its liability and the company's stated assets, stated capital. It means the company has the net value, net value, net state capital shareholders value, then the company is solvent, otherwise insolvent. So the company assets are higher than the company's liabilities and the stated capital. Understand the solvency test. The board should consider. So in the when they are doing the solvency test, there are two circumstances we have studied. A director who believes that company is unable to pay the debt, then he has to call for a solvency, sign of insolvency. Then they have to call for a board meeting and discuss to wind up the company. That is one thing. Another thing is the board is required to satisfy that solvency test when they want to declare the dividend to the shareholders or distribute the dividends. They have to get the solvency test. These are two things. And the board should consider the following in determining the satisfaction of the solvency test. The most recent financial statement prepared in accordance with the Companies Act Section 151, true and fair view of the state of the affairs as the balance sheet date and the profit and loss or income and loss and income and expenditure for the period of balance sheet date. So the most recent balance sheet statement prepared in accordance with the true and fair view of the state of the affairs of the balance sheet date. And circumstances that the director aware or ought to know which affect the value of the company's assets and liabilities. So these are the things we have to consider. A fair valuation or other method of assessing the value of the assets and liabilities. So these are something related to the solvency test. Okay, any doubt on the solvency test? Otherwise we can move into the other section. These all about the sections. I have mentioned the first session of this today's class. This is the continuation of the last class. This is we are just dealing with the primary duty of the directors and use of the information and advice and directors interested transaction, where we have seen what is the director's interested transaction and what are the other requirements they have to follow in the company, and use of company's information and appointment and removal of the directors, particularly the appointment of the directors and the disqualification and other requirement. We have seen several other requirements. Under that, the solvency is one of the important things. If the director believes that the company is unable to pay debts, and then they have to go for a meeting, board meeting, and decide the winding up a decision. And then we have seen the solvency test. And solvency test, of course, the assets are higher than the greater than the liabilities and stated capital. And again, solvency test are some other 11 matters related to the solvency test we have seen. So these are the first part, and I think we have now seen the basic preliminary ideas about the Companies Act and incorporation of companies and all sort of other things, the basic things for an introduction. Basic things have been we have studied, and now we are going to move into the next section. We are going to move into the company licensing, and which are particularly about the finance the finance related business ventures. So any doubt, if you have any doubt, I can clear. Otherwise I can move into the other section. Okay, okay, I missed one more thing. There are some statutory books and registers has to be mentioned by the Companies Act in any company. First one is minutes book, and minutes book, of course, is a recording proceeding of general and board meetings. An attendance book for recording attendance at company and board meeting. And index of shareholders, when the shareholder number of shareholders more than 50, they have to maintain index of shareholders. And share register they have to maintain in a company. A share register recording the shares issued by the company and name, and the last known address of each shareholders, and the number of shares of the class held by during the last 10 years, and should also be included in the date of issue, repurchase, redemption of shares. All other details they have to maintain in the shareholder register. And register of the directors and secretaries, register of the directors, secretaries containing their name, residential address, and business occupation. All sort of things has to be mentioned. And interest register, of course, we have seen several times in today's class. The register to record any transaction or proposed transaction with the company in which director is interested. So see, these are the some of the statutory books and registers a company has to maintain. So I think this is also I have to cover. I just miss it. So you're just, this is very straightforward. When you are reading it, you can get it. The minutes book, attendance book, index of shareholders, share register, register of the directors and secretaries, and the interest register. So these are the some records and books and registers they have to maintain in any company. If you all have any questions, I can answer. Otherwise, I can move into the other section. Okay, since there is no questions, I am moving to the other major section, the licensing of financial institutions. I have already mentioned to you all that if I want to open a shop, the requirements are very minimum. If I want to open a factory, okay, there are some requirements, but it's compared to the bank or finance company, it is very easier. If I wanted to open other any production or service related company, which is comparably easy. But if I want to open a bank or finance company, the procedures are very stringent and the requirements are very high. Requirements are very high, and there are regulators. And in the regulators, we have to, before starting that type of business, we have to obtain the license from the regulators. Because why the requirements are high, the regulatory requirements are high, because they are dealing with others' money. If it is a shop, or if it is a production company, or if it is any other company, generally the owner's capital is the sizable funding source. But if it is the financial institution, the funding source is the general public money. If it is a bank, the general public deposit will be the huge or large sum of the money involved as a source of fund for that bank or finance companies. So when it is involved with a large number of public, then the requirements are very high. Another thing is, if there are failure of a particular financial institution, which will have high repercussions or consequences to the macroeconomic environment. That is other important thing. For example, if there is a shop which is closed by a shop owner at a particular day, there will not be much microfinancial implication. Okay, who knows, who cares? The person who is the customer sometimes may feel it, okay, this shop has closed down. Then they will gradually move to other shop and they will just pay the money and get the services or goods. If it's a hotel close, of course, there won't be much microfinancial implications. There will not be much impact to the economy. But for example, if a large bank collapses, even not only large bank, a medium size or small finance company collapse, that impact to the microfinancial environment or economy is huge, because that may create a lot of impact to the economy and lot of the impact to the financial system, because the people may lose the confidence on the financial system, because financial system is running basically or purely based on the trustworthiness. Why we are giving the money, why we are depositing the money in a particular bank, because we trust on the bank. Okay, we believe that, okay, if we are giving the money to them, we can get it that money after 1 year period. That with the trust only, people go and deposit the money with the financial institution. So the financial institutions are opening, when they are opening the financial institutions, the conditions or licensing are very the regulators are asking high requirement for the licensing. Okay, so that purpose, first we have to see what are the financial institutions are in Sri Lanka. I just asked from you all, how many of you all reading annual reports of the central bank? How many of you are reading the annual report of the central bank? That's a question, of course. I just attended that question, and sir, who will record those books? Actually, the board of directors and company secretary, those people will maintain the, especially in the board of directors or company secretariat, people will maintain a particular these type of register. For example, there are different register we have discussed. The minutes books, of course, minutes book will be the board secretary may have these minute books, and attendance register, of course, the board secretary may have. And because board secretariat, there will be in any companies, the bigger companies and banks and all, you can see the separate board secretary, and the board secretary maintain the minutes book, attendance register, and index of shareholders. Of course, yes, it's the board secretary and share registers. Most of the things will be maintained by the board secretariat people. Okay, then just we'll move to the finance. Okay, how many of you all read the annual report? I hope you all. I think at least you would have seen the annual report of the central bank, and in the annual report there are 8 chapters, which 8 chapters are talking about the different sectors of the economy. For example, the first chapter is an overview, and chapter 7 is about the price and wages, money and bankings and all information, and chapter 6 about government finance. And particularly, this is what I wanted to tell you, the chapter 8 is about the financial system stability. So chapter 8 of the annual report talking about the financial system stability of the country. So in the second page or first page, of course, the second page maybe you can see this type of table in that chapter 8 of the central bank annual report, where we have mentioned, the annual report mentioned all the total assets of the financial institutions. Okay, all the total assets of the financial institution, there will be a comparison between that. Always they are compared with the particular year and before the previous year. So the last annual report, which published in the last March, is containing the information of the 2019, and they are compared with the 2018. Okay, with the table you can see, identify what are the sectors and what are the institutions in the financial system. The first one is the banking sector. The banking sector, there are three type of the institution. What are those? The central bank. Central bank also coming under the banking sector. So the central bank and licensed commercial banks, licensed specialized bank. Okay, central bank, of course. Okay, we can just we know, everybody knows about the central bank and all, and we will come to the licensed commercial bank and licensed specialized bank. In the bank, there are two category of financial institution: licensed commercial bank and licensed specialized bank. Now I am going to ask some very simple questions. Everybody may know that. What is the main difference between the licensed commercial bank and licensed specialized bank? What is the main difference? What is the main difference between licensed commercial bank and specialized bank? Come on. You all maybe work in the financial institution. Yeah, there's an answer. Obviously, maintaining current account. Because licensed commercial banks can maintain the current account with the customers, or they can maintain the customer's current account, but licensed specialized banks not given that privilege. But I think the proposed Company Act they are going to abolish, but it's not still not enacted. But the present Company Act, there are two type of banks: licensed commercial bank and licensed specialized bank. Even the directions and regulations are different for a licensed commercial bank and specialized bank. Particularly, the capital requirements are different, liquidity requirements are different, and there are different requirements for the licensed commercial banks and specialized bank. Okay, these two are the three banking sector has the three type of institution: central bank, licensed commercial bank, licensed specialized bank. Okay, what is the other one? Other deposit taking financial institution. The licensed finance companies, which everyone knows that these days the topic in the licensed finance companies. Licensed finance companies are the category of the institution which can be accept the deposit from the public. So licensed finance companies which is not a bank, but they can accept the deposits and they can grant the loans. And other one is cooperative rural bank. I think you all may know that in the village level there are cooperative rural banks, and which also can be accept the deposit. And theft and credit cooperative societies also can be accept the deposit. When you are seeing that in the table, you can see that central bank has the 9.5% of the total asset base of the financial system or total financial institution. Out of the total financial institution total assets, the central bank representing 9.5% of the total assets. And licensed commercial bank, which is the highest sector, which representing 54.3%. And licensed specialized bank, which has only 7.8%. Okay. And other deposit taking financial institutions, where licensed companies representing 7.4%, and cooperative rural bank 0.8%, and theft and credit cooperative society 0, which is very their asset size is very low. And specialized leasing financial institution, where they are under that there are several institutions, specialized leasing companies, primary dealers, stockbrokers, unit trusts, market intermediaries, venture capital companies. These companies cannot accept the deposit, of course. But unit trust, of course, they are getting money, but as an investment, it's not a deposit. Specialized leasing company, they can't get the deposit, but they can involve in the leasing business. And primary dealers, of course, they are dealing with the government securities market. And stockbrokers, of course, you all know that. And unit trust or unit trust management companies and market intermediaries, venture capital companies, those are considered as a specialized financial institution. And there are other category, contractual serving institutions, where insurance companies, employees provident fund, employees trust fund, the superannuation funds are coming under the superannuation funds, and insurance companies are coming under these sections. Understand? So these are the financial sector, the financial institution in the financial system of the Sri Lanka or the country. The total asset size is 18 trillion. In 2019, 20 trillion. The total asset size of the financial institution or financial system is 20 trillion. Understand? Okay. So when any person wanted to open these type of financial institution, there are licensing procedures. So they have to follow the licensing procedures to open these type of institution. For example, the licensed bank and specialized bank. So we are going to see one by one what are the licensing procedure to open these type of financial institution. Understand? Any questions? When we differentiate LCBs and LSPs, can we consider offshore banking as a different other than maintaining current account? Yes, that's also one of the, there are differences. One is the maintaining current account. Other one is offshore banking unit, FCBUs. FCBUs generally, the licensed commercial banks are having the FCBUs. So they are permitted to foreign currency transactions. But licensed specialized bank, of course, offshore banking business, they are not permitted. So that is also agreed. That is also one of the difference, offshore banking unit. But the main difference, if somebody asks the main difference, the maintaining current account. But this is also considered as a one of the difference. But in the foreign currency transaction, of course, we have given the approval to the NSP as well. NSP can mobilize the foreign currency deposits. We gave special approval for NSP, I think. So there are some exceptions. Okay, I think you would have understand it. Then we will move into this. Okay, any doubt on these financial institutions and all? Okay, I think this is very straightforward, and we will move into the other sort of information about the financial regulators. We have seen the financial institution and financial regulators. When we are calling the financial regulators, generally, most of the people are thinking that central bank is the financial regulator. Of course, that is in a way it's true, but it's not exactly correct answer. There are different regulators in the country. The central bank is one of the prime regulators, but there are other regulators as well. They are regulating financial institutions. So these slides discuss you all that what are the regulators available in the country. First one is the Central Bank of Sri Lanka. As everybody knows, that Central Bank of Sri Lanka is one of the main regulator, and in the under the central bank they are regulating licensed bank, licensed finance companies, leasing companies, primary dealers, payment service providers. Payment service provider, now there are several payment service providers in the mobile, through the mobile act, apps and all, credit card and all, there are payment service providers. So those payment service providers also regulated by the Payment and Settlement Department of the Central Bank. Okay, so these are the institution regulated by the Central Bank of Sri Lanka. Licensed bank, of course, regulated by the Bank Supervision Department of the Central Bank of Sri Lanka. And licensed finance companies and leasing finance companies and primary dealers are regulated by the Department of Supervision of Non-Bank Financial Institution, SNBFI. And the payment service providers are supervised by the the Payment and Settlement Department of the Central Bank. So the Central Bank is one of the main regulator. Under that, these institutions are regulated. And on other than the Central Bank, Securities and Exchange Commission of Sri Lanka also one of the regulator. They are regulating stockbrokers, unit trust companies, and investment companies, margin providers, underwriters. Okay, so unit trust investment companies and margin providers and underwriters, the Securities and Exchange Commission regulated. Mostly they are regulating the investment related companies. And Insurance Regulatory Commission of Sri Lanka, of course, they are regulating the insurance companies. And Cooperative Development Department, of course, you all may heard this is the first time, somebody may heard this is the first time, but they also one of the regulatory department. They are regulating cooperative rural banks and theft and credit cooperative society. Theft and credit cooperative society, they are regulating. So if somebody asks, so in the exam, if there is a question that please write down the regulators of the country, you have to write down 4 regulators. Who are they? The Central Bank of Sri Lanka, Securities and Exchange Commission of Sri Lanka, Insurance Regulatory Commission of Sri Lanka, Cooperative Development Department. These 4 the regulators are regulating financial institution mentioned here. Understand? Okay. If you have any questions, I can answer. Otherwise, I'll just move to the other section. Actually, there are more slides has to be discussed, and we will start with the licensed commercial banks and licensed specialized bank. There are regulatory procedure for licensed commercial banks and licensed specialized banks. As I mentioned already, if any person wanted to start the license commercial, any company wanted to start the license commercial banks business or license specialized bank business, then there are some requirements. There's licensing of the commercial bank, the licensed commercial bank and specialized banks, and the license are given under the Banking Act number 30 of 1988. So this is the number, the Banking Act, you have to keep it, remember, number 30 of 1988 Banking Act. This has been amended several times, but the prime act year is 1988. The business of the commercial bank or specialized bank can be carried out only with the authority of the license issued by the Monetary Board of the approval of the and with the approval of the minister. Who are the Monetary Board? The Monetary Board is the governing body of the Central Bank of Sri Lanka. The Central Bank of Sri Lanka, actually, the powers are vested to the Monetary Board. Monetary Board. There are 5 members. There are 5 members in the Monetary Board, and that powers, all the powers are vested to the Monetary Board. They are like a board of directors of a company. This Monetary Board are the supreme body for the Central Bank. They are the people, decision-making people. And so the license has to be issued by the Monetary Board with the approval of the minister in charge to the Central Bank. Generally, the finance minister, with the approval of the finance minister, they can issue the Monetary Board can issue the license to start a commercial bank or specialized bank. Understand? Okay, licensing procedure. There are 4 procedures to grant the license. First, they have to submit a duly completed application. Then application will be assessed or assessment of the suitability of the application by the Central Bank of Sri Lanka, and then it will be given to the Bank Supervision Department. Then that will be given to the Monetary Board, and Monetary Board will take the decision whether it is need to be started or whether they are comply with the requirement. Another thing is issue of the letter of provisional approval. Before, okay, they are satisfied with the approval, they will issue the provisional approval letter to the particular company and issue of the banking license. After they fulfill some condition, they will issue the banking license. So these are the procedure to get in the licensing of the bank. Under that, the first one is the submission of the approval. So I say that there are 4 provisioning, 4 requirement. The 4 steps. First steps is submission of the application. The submission of the submission of the applications. An application for a license should be made in writing to the Monetary Board in the manner determined by the board. Okay, the Monetary Board determined by the Monetary Board, they have to submit the application form. So profile of the promoters, directors and major shareholders, objective of setting up a bank, capital and shareholding structure, names and CVs of CEOs and other senior officers, training facilities, staffing, technological status, planning for branch expansion, business projection. There are a lot of information has to be given with the application form. The exact detail can be obtained from the website of the Central Bank of Sri Lanka. If you go to the Central Bank of Sri Lanka website, you can go to the banking supervision. Under that, you can get all these information. There are a lot of information. Who are the promoters of the bank and the directors, the major shareholders, and all sort of information has to be submitted with the application form to the Monetary Board of the Central Bank of Sri Lanka. Okay. Once they submit the application form, what they have to do, particularly they have to submit some minimum documents. I have mentioned they are the promoters and major shareholders, objective of the setting up a company and all sort of information. Other than that, the legally, in case of local bank, they have to attach some other information, documents. First one is copy of the article of association or the constitution or any other document associated with the formation of the company. So generally, if it is a company, the article of association has to be given. Okay. And a second one is statement containing the name, address, occupation and qualification of the directors and CEOs. Okay, so these are the directors, their qualification and everything has to be given as directors and CEOs, and copies of the audited balance sheet and profit and loss account for preceding 3 years period. So these are the information, and these are very straightforward. I think I need not to much elaborate it. These are very straightforward. They have to give these documents. And in case of companies incorporated outside Sri Lanka, the first 3 are, of course, we have already seen that the copy of the article of association or constitution or any other document association with the formation of the company, the statement containing the name, address, occupation, qualification of the directors, copies of the audited balance sheet for preceding 3 years period. In addition to those 3 information, they have to give 2 additional informations. 2 additional information has to be given in case of the companies incorporated outside Sri Lanka, especially for the foreign banks. The branch of the foreign bank, they have to give some 2 additional information. First is a written undertaking supported by the resolution of the Board of Directors stating that on demand by Central Bank of Sri Lanka, CBSL means Central Bank of Sri Lanka, such company would provide such fund as may be necessary to meet all the obligations incurred in connection with its business in Sri Lanka. It means if there is any requirement arises, the parent company, which company in the abroad, incorporated in abroad, will provide fund for to this particular operations in Sri Lanka. And approval from regulatory authorities in which the company is incorporated. What does it mean? For example, State Bank of India or Indian Overseas Bank or ICICI Bank, when they wanted to open a bank, the branch in here, the bank here, what they have to do is they have to give all this information, and in addition to that, they have to get the approval of the RBI to open a branch in Sri Lanka, and the copy of that approval also has to be submitted with the application form. Understand? If it is a public bank Bergad, they have to give the application for the approval from the Bank Negara Malaysia. So wherever they are having the banks or their company, the parent company in the outside Sri Lanka, they have to get the regulatory approval from those regulators, the particular country's regulators, and they have to give with the application form to the Central Bank of Sri Lanka. So these are in case of outside. So there are two types. One is in case of locally incorporated company. Other one is in case of outside company. And the criteria for assessing the suitability. There are some criteria to assess the suitability for the central bank. Any doubt on these documents? Of course, these are very straightforward. There may not be much doubt. Okay. The criteria for assessing the suitability, the interest of national economy, the central bank, once they receive the application form, they will check whether interest of the national economy and the banking needs of the country, whether there's a real need for a bank. That is the first thing. Whether this application is suitable or not, first they will think, they will assess whether there's a need of the banking need for a country. If the monetary board feel that okay, there are enough bank, we need not to have another bank, additional bank, then they will not provide the license. That's the first condition. The interest of national interest of the economy and the banking need of the country, they will decide. And second one is validity and acceptability of the documents and the information submitted. They will check. And financial status and history. And sustainable suitability of directors, CEO, and other officers performing executive function. For example, a director or CEO, he is a person, he is earlier, he does not have any banking knowledge. There are directors, but director does not have the banking knowledge or adequate finance type of experience. Then they will see whether they have the suitability. And adequacy of the capital, that is most important thing. How much of the capital they are going to infuse? Because for a bank, its a capital is an important thing. So they will just assess that. And ability of the company to meet all the obligations and liabilities incurred in the conduct of business in Sri Lanka and comply with the laws. And compliance with the statutory and other requirements relating to application. This is sort of control basket. So these are based on these criteria, the monetary board will assess the application submitted by a particular company. Understand? Okay. Then the issue of a letter of provisional approval. This is the third stage. Okay. Once the company submitted the application, and then the company submit the application, then the central bank assess the criteria. Once they satisfy, first they won't issue the license. First they will issue the letter of provisional approval to the particular company. It doesn't mean that they will issue the license. If they issue, sometimes they may issue the letter of provisional approval, but they may not issue the license. But this is sort of the pre-arrangement. The letter of provisional approval, generally they put some conditions. Okay, you'll have to meet some condition within 1 year period. If you are satisfactorily meet that, we will provide license. It's a sort of conditional letter. If the monetary board is satisfied that application may be approved in principle, a letter of provisional approval would be issued to the applicant. On the receipt of provisional approval, the applicant should take all measures required in the such letters. Okay, in the letter, there are conditions. All measures required in the such letters prior to issue of the letters. And issue of the letter of provisional approval does not bind the monetary board to issue a banking license. That is an important part. Understand? Then other one is, the fourth one is, then okay, if the bank applicant and it has been assessed, provision and letter was issued and that conditions also fulfilled, then the monetary board will issue the license. Where the board is satisfied that license can be issued to the applicant to carry on the business, banking business, the board will issue the license to the approval of the finance minister. So license actually approved by the finance minister. The license will specify the three things mainly: authorized businesses, places and areas to operate, and terms and conditions subject to which the license is issued. And license should be displayed in all business premises. The banking license, when a company get a banking license, copy of the license should be displayed in all the business premises. So these are the 4 procedures the following in the banking license. If there is any questions like that, the banking license, what are the procedure following that? There are 4 things. One is submission of application, assessment of suitability, and issue the provision of letter of provision approval, and issue the banking license. These are the 4 things they will issue. Understand? Any questions? Okay, if it is there no questions, I am moving to that. The banking, okay, once they get the approval, license, there are permitted business only which can be carried out by the banks. Okay, this Banking Act Schedule number 2 and 4 describe the permitted banking businesses and the subsidiaries of the and associates. The licensed commercial bank can have only licensed commercial bank as a subsidiary. That is a main condition. The licensed commercial bank cannot go and open a hotel. They can't. They have to have. They can have only licensed commercial bank as a subsidiary. But there are some exceptions. With the pre-approval, those exceptions can be permitted. But which are training related to the banking, accountancy, and valuation. If there is any subsidiary companies to provide the training to the staff and accountancy and valuation for a purpose, then they can have the subsidiary. And a higher purchase transaction, medium and long-term credit for development, leasing and warehousing type of businesses, management consultancy, business not inconsistent, and the businesses should not be inconsistent with the business of the banking and finance. Then they can, with the pre-approval, they can open subsidiary companies. Other than that, the licensed commercial bank only have a licensed commercial bank as subsidiary. And the business permitted in the Schedule 2 and 4 can be are permitted to do by the licensed banks. And permitted by the banking business of receiving funds from the general public through acceptance of the money deposit payable upon demand and use of such fund is all or part for advances, investment, any other operation authorized by law or customary banking practice. Okay, what type of mainly what they can main business is acceptance of the money by way of deposits, and the deposit should be payable upon demand or the date, and such fund, the deposit fund, can be used to grant the advances or to make investment or any such other operations approved by the law or customary banking practices. In the case of specialized bank, business of accepting deposit of money, investing, lending, and such money. There are some spelling mistakes, I think. Okay, these are the permitted business by the licensed commercial banks. An institution authorized to accept the deposit, lend, and invest such money. Okay, we have already seen these things, and I think I need not to mention. I think in the first this chart we have seen the deposit taking financial institution. We have listed out this, but anyhow we can see that following institutions are authorized to accept the deposits and from the public, licensed commercial banks. These institutions are called as a deposit-taking financial institution. There may be question. Okay, what are the deposit-taking financial institutions? It's a general knowledge. Whether every financial institution become the deposit-taking financial institution? No. There are certain institutions only called as a deposit-taking financial institution. The first one is licensed commercial banks, licensed specialized bank, registered finance company, building societies incorporated under the National Housing Act, cooperative societies registered under the Cooperative Operations Societies Law, non-profit making organization that accept deposits only from its registered members and has obtained written approval of the monetary board. This is sort of exceptional case. Non-profit organization can be accept deposit, but with a written approval from the monetary board, but only from its members they can accept the deposit. Other than that, generally licensed commercial bank, licensed specialized bank, finance companies, registered finance companies, cooperative societies registered under Cooperative Society Law, and building societies incorporated under National Housing Act are allowed to accept the deposits. Understand? The institution authorized to accept deposits. These are called the deposit-taking financial institutions. Yes, at final, I think the word use of word as a bank, because everybody cannot use the word of bank. Only authorized people can use the word bank in their company name. Use of the word bank or any its derivatives, its translations or equivalent to any language as part of the name is restricted. There are some restrictions to use the word of bank or its translation of that word. All licensed banks should use at least one of the above words except any foreign bank that does not have any such word in its name. Okay, except foreign banks, all licensed bank, the local domestic licensed bank should use the word the bank or its meaning. No other company, firm, individuals or group of individuals should use any of the above word without prior approval of the monetary board. Monetary board in approval without approval of the monetary board, they can't obtain they can't use the word bank. The subsidiary of the bank associated for the protection of the bank interest in registered trade union of the banks, banking institution under MLA, etc. are exempted. There are some exceptions to use the word bank. So these all about the licensing of the bank. I think this is the last slide today's class. If you have any questions, you can ask, or otherwise I can wind up the today's class. and we can move to the licensing part of the other finance institution, licensed finance companies, insurance companies, and all with the next class. And from that, we will move into the other areas which is more prominent to the subject in terms of exams. These all are some preliminary knowledge given to you all. So as I mentioned already, it's a purpose of getting knowledge as well as setting the exam. So these are the things that we have discussed. Do you all have any doubt? Can't they open an IT company? They can't. Yes, actually they can open an IT company, but that IT company should have the main business to provide the service to the particular bank. If the IT company, for example, for their core banking for their software, to maintain their software, and they are maintaining their the service system of the bank, then they can open. But they can't just open the IT company for to provide the service to the other vendors, other customers. If it is related to the banks, of course, okay, but otherwise no. But if it is, if they provide to the bank, of course, okay. Okay, if you all don't have any other questions, then I can wind up today's class. We will meet next Saturday at same time. Thank you so much.